Friends, it took 20 years for a rape victim to get justice from the Supreme Court. Recently, on November 2nd, 2018, the Supreme Court of India, led by Justices Madam Bhanumati and Indu Malhotra, they have delivered a very apt and correct judgment regarding the rape case. So, here the rape case was decided in criminal appeal number 2299 by 2009, and this case is called as State or Government of NCT, Delhi. NCT means National Capital Territory versus Pankaj Chaudhary and others. This case was filed before the Supreme Court in the year 2009. Right. When we go into the details of the case, what happened on the day? On 28/7/1997. I repeat the date, 28/7/1997. Then the victim, she was in her house and the neighbors, there were about 4 persons. They entered the house at about 9:30 p.m. And first of all, they pretended as though they came for a BD. She said no. Then they asked her for the water. She said she will not give. And ultimately what they have done is they have switched off the electricity and committed the heinous act of rape against her. So she felt hue and cry. She raised a hue and cry, and her mother came only after a little later, by which time she fell down unconscious. She received injuries also. She fell down unconscious. Then her mother called 100, that is police control room, and the ASI, Mr. Kamal Dev of Khas Police Station, Delhi. He arrived there. He took the woman to the government hospital, that is All India Institute of Medical Sciences, New Delhi. There her statement was recorded. A case in crime number 559 by 2007 was registered under section 376 clause 2 of the Indian Penal Code. Right? So this happened in the area called as Bhagat Singh Juggi Marg in Hatwaria Sarai in New Delhi. So the limits is Khas Police Station. So promptly they registered the case, they investigated the matter, they arrested the accused and sent them to judicial custody. They filed the charge sheet also. The trial court held all the 4 people responsible for the heinous act of rape, and sentenced them 10 years imprisonment. Fine. So now the story starts from here. In the year 2009, accrued by the orders of the district court, the appellants, that means the accused in the rape case, they filed an appeal before the High Court of Delhi. So their main contention is that this woman who filed the rape case, she was a woman of immoral character. She is a woman of no virtuosity, and she is an easy approachable woman. In other words, we can say that they pleaded that she is a prostitute, maybe a sex worker. But still, the Supreme Court held that even though she is a sex worker, even though she is a woman of loose morals, even though she is doing promiscuous sexual intercourse by taking money, she has got her own will and intention. You cannot go against her wish. That means if she is not obliged, then you cannot go and commit the act of engagement with her. You cannot. It will be amounted to tantamount to rape. The Supreme Court has very clearly stated. So here the High Court, what he has done is, High Court took the appeal on file, then they took the contention of the appellant. The appellant stated that she is a woman of loose morals and she was quarreling with others. Since she was resorting to prostitution, they filed complaint against her in the Khas Police Station, Delhi itself. So this woman and others, they were called to the police station on the same day, that is on 28/7/1997 around 8 p.m. So when these people quarreled, then they booked a case of affray, that means under section 160 of the Indian Penal Code, causing nuisance in a public place. It is called affray. So a case in 558 by 97 under 160 IPC was registered against this woman who was there in the police station up to 8:30 p.m. The High Court is of opinion, when the incident up to 8:30 when they are there in the police station, how can this incident happen at 9:30 p.m.? So the High Court took this view and they believed the alibi petition of the accused. And since they took into consideration the evidence of the ASI who came in PCR, police control woman, he stated that this woman told him that these people created nuisance and they injured her but not raped her. Right? But the medical report, she was produced before the magistrate. The medical report clearly shows that there are 4 into 4 inches size bruises on her both legs. That means she resisted them and they committed the heinous act of rape. So friends, please remember, even though the woman of immoral character, her resistance itself amounts to the allegation of rape. Moreover, the medical evidence is very clear that the bruises were there, the injuries were there. They say that these accused used force against her. Definitely. Supreme Court held that the High Court has not erroneously, decided the matter basing on the premises and surmises. They thought somewhere they solely depended on the inquiry report of the Joint Commission of Police, Delhi, wherein what inquiry report? It deals with normally only the procedural aspect. A judge only will decide whether there is enough evidence or not. Then the legal principle is the case should be proved beyond all reasonable doubt. If there is any doubt, definitely the advantage should go to the accused. But here, what the High Court done is totally erroneous and wrong decision. And she is not an accomplice. She is a victim of the circumstances. Therefore, the Supreme Court held that the High Court is wrong. Now, the appeal is allowed by the Supreme Court and the accused are asked to serve the remaining period of 10 years. And actually, the High Court also did another thing. They have asked the government to initiate action against the ASI, Kamal Dev and Deputy Commissioner of Police under 193 IPC and 195 IPC also. 193 IPC says that if you give false evidence against any person, it comes under 193. 195 is if the offence is punishable with death. In such cases, if you give a false evidence, then you are liable for punishment under 195. Actually, accused by this, the police officers, deputy commissioners, they approached the Supreme Court, and now the Supreme Court, led by Justice Bhanumati and Indu Malhotra, they have delivered this beautiful judgment. So please study the judgment carefully and correctly. And previously, there are so many decisions right from 2006 in this line. Please remember that even though a woman is not a virtuous character, she has got a right to deny. If she denies, you cannot engage her. If you want to enjoy her, definitely it will become a case of 376 clause 2 because it is a rape against her will. Thank you.